Struggling with debt? We have answers for you. We'll be right back. Welcome to Inspired Conversations. I'm Diane. Today we have with me Laura Donaldson and John Cooney with Cooney Donaldson, Attorney at Law, Debt Relief Lawyers. Thank you for joining me today.
Thank you for having us.
Now, you get questions asked all the time, and our audience at home is going to get the answers that you, and the questions and answers, so that they can learn at home how to get out of debt. What can they do if they are in debt? So, first let's start off with, there are two kinds of bankruptcies, is that right? Are there more than two?
Well, there are more than two, but for individuals rather than corporations, there's two primary bankruptcies that are used. A Chapter 7 bankruptcy and a Chapter 13 bankruptcy. Just briefly, the Chapter 7 is a quick process. It lasts about 3 to 4 months from the beginning to the end. It's a liquidation bankruptcy, so we pay very close attention to the assets. We've got exemptions to protect assets or stuff up to certain dollar amounts. If the assets exceed that dollar amount, that you risk liquidation by a trustee. In determining, when I think of a Chapter 7 bankruptcy, I think of it really as a two-part analysis. The first is the asset side. Do you even want to file Chapter 7? You're going to lose all your stuff. The second is eligibility. Can you even file?
Did you say if you file Chapter 7, you will lose all your stuff?
No, the question is that going to happen? So or are your assets protected by the exemptions that are available to you?
Okay.
And if they're not protected, then you probably aren't going to want to do a Chapter 7 if you're going to want to keep that. You can protect those assets in a Chapter 13, which I'll talk about, Laura will talk about in a second. The second requirement of a Chapter 7 bankruptcy is looking at your income. You know, do you make too much to be in a Chapter 7 or not? And that's a part of the analysis. So when we're looking at it, what we're always looking at is the assets and the income. And then, you know, if at all possible, we'll do a Chapter 7. If not, then we can go through a Chapter 13.
Absolutely. And Chapter 13 is a reorganization plan. So Chapter 13s last 3 years or they last 5 years. And whether we put somebody in a Chapter 13 depends on whether they have equity in their home, if they have equity in their cars. If they're higher income folks that don't qualify for Chapter 7, we'll put them in a Chapter 13 reorganization plan.
And you make the best choice for people coming to you because they probably don't know what they should be in. Is that correct?
That's correct. Most people don't know. We do see a lot of individuals who file their own cases, and sometimes it can be troublesome, especially if we're sitting in a hearing for a Chapter 7 and we see the trustees, who are the parties assigned to oversee cases, taking an interest in someone's home or their cars because they didn't properly protect them, or they really belonged in Chapter 13. And there's things that can be done if that happens, but as a lawyer, it's hard to watch that take place because we don't want to see people lose their stuff. We want to help them keep it. So that's why we say we have an initial no obligation consultation. We have people come in, they fill out a worksheet that details their assets, and then we talk about the differences between 7 and 13 to them so they can make an informed decision before they move forward.
Well, it doesn't seem like filing bankruptcy should be a do-it-yourself project.
Although individuals can file bankruptcies on their own, in most situations you're going to be better off with an attorney that knows the rules.
Yeah.
Absolutely.
Okay. So a lot of people, one of the first questions, am I going to lose my house?
Right, and that really is driven by, you know, number one, can you afford it? Are you making your payments? You know, if you can't afford to make the monthly payments, then bankruptcy is not going to help you keep the house. Assuming you can afford to keep the house, then the question is how much equity is in the home? Again, we have exemptions under Oregon law. An individual filer has a $40,000 exemption. A joint filing, husband and wife, has a $50,000 exemption. So that's the amount of equity that can be protected. If the equity exceeds that in a Chapter 7, you risk liquidation. In Chapter 13, we do a hypothetical liquidation and say, okay, if we would have done a Chapter 7, after cost of sale, after trustee fees, how much actually would get paid to the creditors? And that's called the best interest of creditors number. That's the amount that has to be paid to those unsecured creditors over the life of a 13 to protect that asset. So that's the method that we use in 13 to protect assets, and it can be equity in home or cars or anything else.
Okay, so a 7 is quick and easy, but you lose assets,
Potentially.
potentially.
And the difference in a 7, like John had said, is most people want to do a 7 because it's a 90-day process. You're in it, you're out of it, you're done with it. But the risk is if you have assets that the trustee can liquidate, and liquidate means sell and pay your creditors with, you really don't want to step into that process without knowing that can take place. So,
Wow, there's a lot of serious implications that have to be considered, definitely.
absolutely.
So, another question that you have frequently asked is about wages that are garnished. What can you say about that?
So wages that are garnished, the biggest thing that I hear is I received a judgment, I got a lawsuit in the mail, that's how it generally starts, and people don't respond because they are afraid of responding. They have fears about, I don't have an adequate response, I do owe the money, so what am I supposed to go in and say? I don't want to see a judge, I don't want to be judged because I can't pay this bill. So they do nothing. And then the judgment gets entered. It's called a default judgment, where the court says you owe this money, and now we're going to give this piece of paper that's a judgment to the creditor, and they can go forward and find your assets. So going forward and finding your assets mean they look at bank accounts, they look for your wages, they look for unprotected assets that they can take to pay this bill. And that's where a garnishment comes from. You'll next receive a note from your bank that says that this creditor's taken all the money out of your account. And unless you have an exemption to apply, and you have to actually apply for that exemption, they'll keep that money. Wage garnishment, they'll serve it on your employer. Your employer notifies you. The creditor's going to take this money unless you have an exemption that applies. So it's a very scary process.
I would
we
say,
hear people come in and say, I can't afford to have 25% taken for this creditor every month. It's a large amount of money. I need it for my rent. What can I do? When you file a bankruptcy, the bankruptcy stops the garnishment.
Okay, all right.
So there's a provision of the code called the automatic stay, and the stay goes into effect when the bankruptcy is filed, and that stops all creditors from any further attachment or state court action.
Regardless of what the garnishment is for, because I know that I've heard of garnishment for child support.
That's an exception.
That is an exception.
Okay.
That is an exception. The state does want you to pay for your kids, so that is an exception. But in other instances, too, if you've had money garnished in the 90 days prior to filing involuntarily, we can oftentimes get that back.
Wow.
It's called a preference payment. So there's things that can be done, but it's better to see a lawyer sooner rather than later, so those steps can be taken.
Right, okay, wow. So someone's on Social Security disability with a limited income, and the bill collectors are calling.
All right, this happens all the time to us, to my clients, and Social Security income is completely protected. It cannot be garnished. It can't be seized by creditors.
Even disability?
It-
I mean, it's part of it, right?
That's correct.
Okay.
Except for with one exception, the IRS can and has in some situations taken some Social Security, but other creditors are not allowed to do that. And so in that scenario, if you've got Social Security income only, you don't have any other non-protected assets, you're effectively judgment-proof. If a creditor comes and gets a judgment, as Laura was talking about, what are they going to garnish? They can't garnish bank accounts. They can't garnish wages. There are none. They can't foreclose on homes or seize assets because they're all exempt. So in that situation, we advise our clients, you don't really need a bankruptcy. You could just, not pay and walk away from this. A lot of our clients don't want to deal with the calls and the letters and all of this. So many of my clients opt to go through a bankruptcy just to get rid of that, those old debts, so that they just don't have to have that walking forward.
Wow, wow. Okay, so next question that comes to you frequently, 2 people are getting divorced and their divorce attorney suggests bankruptcy. Should they do it together or before or after?
That's the
a good
question.
So when people come to us in that situation, it's difficult. We generally like people to be through their divorces, so the property division is done, and we know who's getting what, and because the trustee is going to ask in a bankruptcy situation. As far as filing together, if they're amicable, getting along in the divorce process, and they say, look, we're agreeing to split everything, but at the moment we have all this joint debt together, and we just want to get rid of it so we can get a fresh start.
And that usually that's the best scenario when you have really
To do
minimal.
it together, you're saying?
Well, yeah, to do it together, but to do a bankruptcy together just to clear out the debt, but only really in a situation where you don't have a bunch of assets that are going to be divvied up, and you don't have issues of support, because really that's one of the conflicts that we run into is if one party may have an advantage by waiting to file later on because they will have support or other property that's awarded to them, it creates a conflict for us. So many times we have to go and say, all right, you each need to talk to your own bankruptcy counsel,
That's true.
and if you want to come and do a joint case, then we can do it with you. But we always have to get them to speak to another party as well.
Right, and do conflict waivers as well.
Right.
Because you learn financial information about both, and so you conflict yourself out if they later start fighting and one of them says you're their lawyer and the other one says that you're their lawyer, and so it creates a situation.
Well, maybe
so
they're getting a divorce because of their debt.
that's oftentimes the case, absolutely.
Yeah.
So if we can help in that way, we do the analysis initially and say, okay, what's the situation? Are you arguing about support? Are you arguing about assets? If you are, one of you goes and sees one lawyer and the other goes and sees another
Can you?
lawyer.
Well, oh, you're the same firm.
Yeah.
I was going to say,
We could
she can come to you
Yeah.
and he can go to you, and you two can fight it out. No.
Yeah, and the question too often becomes, well, my husband ran up a bunch of debt and I didn't know about it. But husband used the debt to pay the mortgage because he had been out of work or they overspent. And so we have these issues. So if husband isn't on the debt, or husband's the only one on the debt, but I'm not on the debt, do I even need to file? And no, I mean, oftentimes they don't
You're
need
talking
to
about
file.
people who are still married. They're
Yeah,
married.
they're still married,
Okay,
trying to figure
okay.
out, going through a divorce, if they should file together, if only one of them should file. There's so many issues related to that specific situation that it is important to talk to a lawyer and figure out what the best option is going to be.
Right.
Okay,
So,
wow. These are complicated.
It can get complicated. It can.
That's why you hire a lawyer. You know,
Yeah.
There's a lot of moving parts with bankruptcy. It's very technical.
Isn't it? Is it? So it's easier if one person who's single comes to you as, I mean, I'm just guessing, as opposed to it being a marriage or a
Well, if
marriage
it's
in trouble or a
if the
divorce.
marriage is solid and there's no problem with it, then that's just as easy as a single person. If the problems really arise, if they initially are not seeing eye to eye, then clearly they can't do a joint case together. And we also, in 13s, it's a 3 to 5 year reorganization. We run into situations where clients will get divorced while they're in the Chapter 13.
Oh.
And that presents another set of problems.
So they get to split the debt, split the.
Well, it's not
It's
quite that way.
complicated.
Sometimes
Oh.
they'll
Yeah.
elect to just maintain the bankruptcy and get the discharge if they're on the same page. Other times, they'll each have to go and get new lawyers and sever the case
Wow.
and figure
Well,
out how to go forward.
and then we're adding more money or more bills on top of the whole problem original.
That's
Okay,
correct.
we're going to take a short break.
Okay.
And we'll be right back. You're watching Inspired Conversations with Diane. We're with Laurel Donaldson and John Cooney with Cooney Donaldson Attorney at Law, and we will be right back to answer your questions. Millions of consumers struggle to pay their bills. Financial hardship can lead to divorce, health issues, and depression. If this is you, it's time to break up with your debt. The attorneys at Cooney Donaldson are on your side, offering a judgment-free, no-obligation consultation. Their primary goal is your financial freedom. Take your life back. Call the number on your screen today. Welcome back to Inspired Conversations. I'm Diane, here talking with John Cooney and Laura Donaldson with Cooney Donaldson Debt Relief Attorneys and their law firm, Cooney Donaldson in Portland. So we're giving the audience you the most frequently asked questions and answers so you can find out at home what you might need to know if you went to an attorney, and help determine whether you decide that you need to go. It's time to go. So we're on to the next question. I was just served a lawsuit for foreclosure on my house and I want to save it. Is there anything I can do to keep it?
There is. And the first thing that we have to do is find out, can you afford it? So can you afford that monthly payment? And because if you can't, and the bank isn't willing to modify the loan to reduce that payment, there's really little we can do in bankruptcy. As far as the time frame with foreclosures, we need to distinguish between a judicial foreclosure and a non-judicial foreclosure. A judicial foreclosure starts with a lawsuit. It says, you are behind and we want to foreclose. You have 30 days to respond to that. If you don't respond, then the creditor can obtain a judgment of foreclosure and proceed with it. If you do respond to the lawsuit, then it pushes out to trial. You have more time to either get into a bankruptcy or to negotiate with the creditor. And usually it's somewhere between 6 months and a year from the filing of the bankruptcy that a judgment of foreclosure is actually going to be taken in, assuming that you owe the debt and they have the note. Which is sometimes a question. The other form of bankruptcy, or the other form of...
Wait. What'd you say about the debt? Who owned the note?
Well, sometimes there's a dispute over who owns the note. Is there,
You mean which lender, which
Yeah.
bank?
Yeah.
Because
Is
weren't
there
they
proper
kind of
chain of-
passed around?
There's, yes, there was issues of mortgages being securitized and then divvied up, and the question was there proper chain of title? In Oregon, the law has been pretty much resolved in that if you've got a title that's endorsed to bearer, then you own the loan.
What
So
if
the question
what
is,
if
who is the proper party in interest to bring the lawsuit? And so the party that was foreclosing on behalf of the bank didn't hold the note. They were not titled on the note. So people were saying you aren't the proper party in interest to bring this lawsuit, and therefore you can't foreclose on my home.
It's a defense
is
for
it
foreclosure.
true? Is that true?
In some
In some
situations.
situations, but
What if the note can't be found because it was passed around at parties?
well, people have to go through basically a title search and a title audit on their home to determine where the note
And should they do
passed
that?
from who to who.
Because I know when people get a
It's-
thing in the mail, say you're going through foreclosure, they just assume, well, that's it.
Yep.
It's a cost-benefit analysis, really. It's an expensive process, and 99.9% of
Oh.
the time, the lender has the note.
Right.
So we found that it could be more of a scam to get people to pay money to litigate issues that really didn't
Or just to
exist.
try to buy more time
Right,
in the
or buy
house.
more time
And really,
in the
that's
house
that's
without
effectively what it
payment.
is.
Which costs the homeowner more money.
Well, it really doesn't, because they're sitting there without making a payment to the house.
True.
So
True,
it's-
true, true.
You don't have to pay rent, so it's not money in your pocket, but it's not money that you put out either.
Right.
So the other form of foreclosure is a judicial foreclosure, non-judicial foreclosure, which basically the creditor sends a notice of default out and then it issues a second letter that says, we're going to foreclose on your house on this day, and it's got to be at least 120 days out. So you've got 4 months there. So the time period that you have to work with the creditors between the judicial and the non-judicial foreclosures varies, and it's usually shorter unless you take no action with the judicial. It's usually shorter with a non-judicial foreclosure.
Now, the law that passed recently, or not recently, in the last couple of years, when there were a lot of foreclosures about in the Oregon state legislature that mediation must be done between the lender and the homeowner. How's that working?
It was working. It started out with a rough start, but it was actually helpful because you have the homeowner along with a representative from the bank that goes to this mediation, and the homeowner can bring in a lawyer with them if they choose to. And basically, they talk out their options. Does the homeowner have enough money to restructure the loan under a modification? Does the bank have a program that's available to the homeowner to restructure their home loan, maybe give them a lower interest rate and reduce their payment? But most of the time what it came down to was, can homeowner afford the loan?
Doesn't a bank, no, okay, so does the homeowner get notification they have to go to mediation? They might not have read this in the newspaper that the law passed.
Yes, no, they get it in every single foreclosure.
That's
They
correct.
do, but there's certain requirements on the banks. The banks have to meet a certain size and certain number of loans before they have to participate. But most banks fall within that.
So smaller credit
requirement.
unions may not fall into that
Oh,
category.
I see. Okay.
So once we have a foreclosure there and we've made a determination, okay, I can afford this property, I can afford making the monthly payments, then the question is, what do we do? Well, we first try to just negotiate with the lender and get a loan modification. That's what the mediation's all about. If that doesn't work, then we can file a Chapter 13 bankruptcy. When you file that bankruptcy, even if it's an hour before the sale, that's going to stop the sale, even if the creditor isn't aware of it. So that stops the sale. It imposes the automatic stay. Then you, 30 days later, resume making your regular contractually due mortgage payments, and then you make a second payment to the bankruptcy court, and that payment's going to be paying off the arrears, the pre-filing arrears. So that's really the crux of it. Can you afford that ongoing payment and the payment to the trustee and cure this mortgage within a 5-year period?
I have a question. Maybe this is too simple of a question, but isn't it in the bank's best interest, the lender's best interest, to do a mortgage modification? Because I know it's hard to have happen, and there's a lot of hoops to jump through, but isn't it in the bank's best interest, or am I missing something?
Not necessarily. The bank really wants the money. They don't want the property. But in today's market, there's equity in properties. So
Right.
if you're high risk and you're not paying on your mortgage, the bank's really looking at, look, if I take this property back into my inventory and I convert it, I'm actually going to get rid of this high risk person and then sell this property and get my money back sooner rather than later, which is different from back in 2008, 2007 when homes were underwater and banks didn't want that inventory. So it is a little bit different.
And one of the questions that many of my clients have when we're talking about this is, well, why can't you just force a modification on this? Why can't we do it through the bankruptcy process? And unfortunately, the only loan that we can't tinker with in a bankruptcy is one that's secured by your primary residence. That we can adjust and modify many other loans.
So if it was a vacation home, you could?
If it was a vacation home, there's different things you can do. The crux with that is what are you going to do with it, and can you afford to pay this off over a 5-year period? Or, so there's different issues that we look at there. But for example, cars. If you've got a car loan that's over 2.5 years old, we can modify that loan. We can say, okay, the value of the car is $5,000 or $10,000. You owe $20,000 on it, so we're going to pay it off at $10,000 at a lower interest rate than probably you have. And we're able to do that as long as the value of the property is down.
Okay.
That's what reorganization is in Chapter 13. If people are really going to get a fresh start at the end of a bankruptcy case, they have to leave bankruptcy,
Right.
getting rid of negative equity in their cars and all the stuff that they were doing trying to get on top of their debt, right? So by the end of Chapter 13, the goal is you own your car, you're rid of your credit card debt, you're current on
the
your
home,
mortgage, you're current on your taxes, and life is good, right? You leave saying, this process, I struggled, and you don't even necessarily need to struggle in Chapter 13, but you get a breather. You get a breather from all of this trying to manage your debt. You get one budget, you get one payment, and then you live within that for 3 to 5 years, and then it's like this aha moment, woohoo, we're done, we got our discharge, and life is good. And it's a learning process, so.
Wow. Okay. So what are the long-term effects of bankruptcy? And I think this is what a lot of people want to know. Will I ever be able to get a loan again? How long will it take? Can I ever buy a car again?
Right.
Is this a death sentence financially?
Well, the credit reports or credit reporting agencies are going to report a bankruptcy for 10 years for the filing, but that doesn't mean your credit is shot for that entire 10 years. If somebody's proactive at reestablishing their credit, they're going to be able to get loans and qualify for decent interest rates. They're going to have to reestablish their credit first. As far as qualifying for a traditional home financing, they have different requirements that seem to change daily. But the bottom line is they're going to say, okay, our new underwriting standards are you have to have at least X many years, 5 years or 2 years or whatever it is, from the bankruptcy before we're going to consider you for a traditional financing. So the bankruptcy does, put you back as far as your credit, but you are able to reestablish it going
And are there organizations that can help clean up your credit report? Because there's oftentimes a lag time between what you've done to clean up your credit and when the reported changes happen.
You don't really need an organization
Oh.
to help you do it. So the credit reporting bureaus have great information on their websites about how you can look at your credit report. Credit Karma is another place you can go, has all of the 3 credit reporting agencies combined into one report. And so you can see on that report what's being reported as derogatory information. And then you can file a complaint, and you can do it online, or there's a mail-in process to do that.
Oh, you file the complaint right there with that?
Sure. So what happens is it goes to the credit bureau, and then what they do is they send it to the creditor, and then
Okay.
they have 30 days to respond, and then they send a response saying, we're looking into it. And then generally what happens is, for example, if somebody goes through a bankruptcy, the information that was in their bankruptcy may not carry forward to the credit report. So when my clients are done with bankruptcy, I tell them, okay, go get your credit report. Let's see and make sure everything is being reported properly. And if it's not, challenge it, get it fixed, because that's the information that helps kickstart your credit once you get out of bankruptcy.
And then there are companies that advertise, we will finance anyone, especially cars.
Well, after you file a bankruptcy, particularly a Chapter 7 bankruptcy, my clients just get bombarded with vehicle purchase requests. I mean, they're a terrible interest rate, but they are out there, some mailing list that they must be on.
I get it.
for filing.
Wow.
Yeah.
Yeah, but your life is definitely not over. I mean, one of the things we counsel our clients to do as well is get a secured credit card, which a secured credit card is basically your money that you put on a card each month, and you use up to that limit and you replenish it. And if you do that on time, and it's usually 6 months to a year, I believe, then the institution, the bank, will turn it into an unsecured credit card that you had, similar to what you had prior to your bankruptcy filing. So you rebuild that way, or through on-time car payments, things of that nature.
Correct.
So.
Okay, good. Well, this was a lot. This was heavy on content, which I am thrilled that the audience gets this kind of information from you. And so people will know how to find you. We will have your website address and your phone number. So if people need, to talk to you, have any questions, they can give you a call. And
Great.
and also
Sounds
getting a complimentary consultation.
Right.
Yeah. Okay. Well, thank you so much for joining me today, and we'll see you again.
Thank you for
And
having
we
us.
will see you again. You're watching Inspired Conversations with Diane. Go to dianetv.com for blogs, and all of these shows you can watch on demand at any time for free. And we will see you next time.